creating groups, enjoying groups, families, societies, and so forth. But that is. So the benefit of this sort of theory is that it brings out those sorts of premises, and then says, well, let's argue about this. It's not simply your preferences. Let's see what are the implications, what are the alternatives. Is this something we have reason to endorse, to respect?
Bernd had a question, and then Josh.
Thank you very much. I found the talk fascinating, and when we're dealing with big themes like this, obviously so much comes from it. I tried to boil it down to two thoughts. The first thought again relates to the Twale link. So I suppose it's worth bearing in mind considering the theme that's developing, that as you move forward with this is likely to be the area of the argument that receives some pushback. But in the same light, it's going to be the space where there's room for genuine contribution here, if we can draw this link to suggest that natural law theory has something to justify and sustain the Twale perspective. My first thought was, is there a worry that actually the principles that we may associate with the natural law tradition, so any overriding inherent principles in human nature, are actually, if they are embedded in any domestic legal systems, it would be Western sort of liberal legal systems that would seek to further these values. So is there a problem? This may actually just be imperialism through other means. And another way to think about that same phenomenon would be if we use humanitarian intervention of an example of natural law in international legal theory. Which states would be enforcing a right to humanitarian intervention? It would be powerful Western states. So that was just one thought that I had. Secondly, I think when we think about natural law and positive law, we should separate this idea of what is international law. Is it a system that's based on natural law or positive law? And what perspective is the advocate or the scholar coming from when they make certain arguments? So where I have the most sympathy with the argument, and where I think there's really something in this, is that as positivism has just taken over international law, I'm completely sympathetic to your claims in that regard. As international law has been positivized, positivism is the lingua franca of international law. Scholars have therefore felt obliged, in my opinion, to construct any legal argument in line with positivism. And I think that can have quite deleterious consequences. That can be really problematic. And if we accept that natural law, by definition, is full of normative baggage, isn't it, in terms of natural law as morality, universal inherent principles. Sometimes positivists can therefore pretend that they're not coming with their own sort of normative baggage. And what I see is an almost normative positivism within the scholarship, which we might want to think about, where any claim has to be justified in the positive law. So we try to reread a treaty provision to suggest that it says what we want it to say. Or we take one or two examples from custom, say, well, therefore there is a new right of custom international law. I wonder actually whether part of your argument might be, and obviously correct me if I'm wrong, that actually scholars are coming from a natural law perspective when they are making certain claims, and maybe we just need to be a little bit more honest about it. Thank you.
Very good. So I'm guided by the principle of sociability to not include section 5 of this, which was because that would have taken another half hour, which was more somehow saying confronting legal positivism with this version of natural law theory, and somehow saying that these are not really competing. There's a way of reading natural law, positivism as a natural law theory, but also that it can't do the job alone. That there are these natural law or other normative theories underpinning all of this. Yeah. And you could do that more confrontational or less confrontational. So what was one thing that I was thinking of, but I left it out here, because going back to the Hobbes presentation point, I think when you read Koskinen, who's a critical legal scholar, he is very clearly, to my mind, in the natural law tradition. So he makes Hobbesian assumptions about human nature and the role of states. That there is, it's all power all the way down. There's a desire to dominate, not without any respect for vulnerability and so forth. And that's how we are, and that's how international law is. So that's a Hobbesian premise. So it's not natural law in the sociability constraint, but it's what sets him apart from the theories that I'm interested in is that he's with Vattel and Trindade almost explicitly not interested in justifying these premises. He doesn't want to go into a justification. And so, but again, I don't want to be picking fights. That's outside the mandate of this paper, somehow the possible contributions. Again, but I get whether the sources of these premises taints them as imperialists, I think is something that I might want to address here or elsewhere.
And in that light, the implication that natural law is individualistic in its outlook may therefore associate natural law with maybe theories of liberalism, which again I think some trial scholars would be minded to push back.
Yeah, and because then I would partly say, well, let's look at the individualism. It's an individualism that insists on one of the defining relevant features is sociability. Right? So it's the interest of individuals in being social that's part of it. So that would be one strand of somehow adjusting the criticism. Another would be a very different track when you read Confucius, the legitimate ruler argues natural law. Mencius, who's Confucius' sort of political theorist, argues that a ruler who has grain in his granaries but does not give it to people who starve is no ruler. He can be killed as any other dangerous animal. Right? So it's, you could find this in clearly non-Western societies as well. Does that make it less imperialistic? Yeah. So this is, yeah.
Josh,
thanks very much. I think I agree with a lot of what you're saying. And a little bit like Ben's going at, I think that this natural law fills in the holes all over the place in fact, like in practice, in terms of interpreting norms, etc., in terms of even negotiating or what we see as like fundamentally legitimate negotiating structures and so forth. But it's just a matter of specifying what we mean by natural law, what aspects of natural law underpin them. So, I mean, even in terms of interpreting a lot of economic law, there seems to be some sort of a quote-unquote natural law assumption about neoliberal values of efficiency and market solutions to everything, etc., etc. Well, I wanted to ask a couple of questions around two notions. One is pathologies in international law. I'm not sure if you might have read, I think it's Patrick Capps, has written a lot about the idea of human rights being based a lot on natural law presumptions, being the point of human rights in public international law being to solve pathologies in public international law. And I think he sort of looks at this way that public international law causes undesirable outcomes and calls them pathologies, and then human rights is supposed to come in and show us how to sort out those pathologies. The problem with that, though, and that's a very natural law thing to me, but the problem with that is that it seems to be that the pathologies are circularly defined by what violates human rights. I'm all for it, mind you. Like, I think that he's onto something in a way, but there becomes a circularity in defining the problem by the tool you have as a solution. And I'm just sort of wondering how you might get around that in terms of your natural law having perhaps some better content or some more non-circularly definable content than human rights has in that sort of instance. And then the second thing that I was thinking of was the terms of negotiating and creating international law. Whether some people might argue that human rights norms being based a lot on natural law theories provide some framework for defining what is and what isn't a legitimate negotiation in creating international law, so therefore defining what is and what isn't actually legitimate international law through the process by which it was created. Just a couple of these slides, like one of the features on the slide on features of natural law, it just made me think that that was an extra step of perhaps another feature of natural law, that it could define the process, the proper process of legitimate public international law, or positive international law. Do you know what I mean? Whether it's a little bit incoherent, sorry about that.
I didn't get the incoherence, but again, very valuable point. I think, again, there's what I could hear or elsewhere, or you could certainly develop this theme that there are normative assumptions underlying most positions in this, but so the benefit of the natural law tradition is that it tries to be more explicit about it, right? But Keynes, I think, says that most of the practical men of this earth, I think he also means women, who think they are completely sort of atheoretical, are usually completely obsessed with some obscure dead economists and philosophers. You just don't know that you have these theoretical presuppositions. So to bring that out is valuable. So the role of human rights, I think, clearly, historically, we can see traces of this concern to constrain the states, in particular, to ensure that their authority is used consistent with these norms. And it may, but I think this kind of theory would leave it an open question to be explored. To what extent should the legal human rights regulate non-state actors? So in the form of treaties, economic treaties, and so forth. It may be that it's wise. It may not. It may, if it reduces the risks. But again, these are legal human rights, right? So it's a matter, again, of institutional engineering that might be beneficial. So corporate social responsibility, it could apply to non-state actors as well. And I think this sort of normative theory, or others that have the same sort of aspirations. So this natural law theory is not my theory, right? But that's I think it serves an important focus, and it is a theory that we could argue about. Now, whether this sort of natural law theory could contribute something to say that processes of establishing positive public international law need to satisfy some conditions, say, of participation or of meaningful veto or some kind of constraints on inequalities of power in negotiation, is, I think, very interesting. I think the premises I have laid out here are too weak. But it would be, one way of doing this would say, individuals have an interest not only in sociability, but individuals have an interest in non-domination, to not be subject to the arbitrary discretion of others. And so when, particularly for purposes of agreeing on rules that will bind us later, one way to avoid domination is to ensure a meaningful negotiating position in the in the process of creating or interpreting. So that would be, but that would then be adding non-domination as a norm here, which then becomes slightly more controversial, but not necessarily.
In a way, although it seemed to, just the slide that you had on the features of natural law, it seemed to almost be set in that slide. In a way, I can't remember exactly the content that was on the slide, but in terms of the function that natural law plays in relation to positive international law, on that slide it seemed to all but say that natural law must be satisfied in the creation of positive international law. It nearly almost said it in that slide, so I don't know whether it's even that much of a bigger step in what you're saying.
Good. This is very, very helpful.
Thomas?
Thank you very much. Echo everyone else's comments. I'll also just start by saying I'm not an international lawyer, and I'm also not a grand sort of theorist in any sense. But a couple of things you said kind of struck me, and I wondered, perhaps I haven't understood it correctly, or maybe there's certainly something that interests me. And it was a kind of your discussion of the natural law theories you presented and the insights as both like an explanatory and normative tool. The kind of filtering through the state was quite strong throughout, I felt. And the particular thing I was interested in was you were talking about principle non-compliance. I think at one point we discussed the example of the German Constitutional Court, amongst others, pushing back, if you like, and you referenced the fact that natural law, as presented through your lens, can help offer some explanatory and perhaps even normative understanding of what's going on there, the references to fundamental aspects of the German Constitution, etc., etc. And of course that echoes some of the things that I've looked at, not from a natural law perspective, but in the EU law context, and push back against the Court of Justice. And one of the problems we have, or one of the issues we have in that EU law context is that a lot of the pushback you get at the positivist level is through the lens of national constitutional systems, national constitutional principles. And what I was thinking, what you sort of said there in principle non-compliance was natural law filtered as through the eyes of the lens of the state. So natural law is the German constitutional what we conceive it. And I just wondered more generally if you could see or conceive or defend a role for natural law in pushing back against international institutions and courts, etc., in a way that is not parasitic on state conceptions, or how do you break? Because a lot of what I was getting the sense of your presentation as an outsider here was that there was a lot of filtering through the state going on, and whether there was a sort of, if it translates beyond that to a set of theories that can be applied without going through the filter of a national constitutional understanding or explanatory or normative of what these natural law values might be. If that makes any sense.
Yes, again, very interesting. So two kinds of comments. One would be, so what I find sort of theoretically interesting in my limited understanding of this objection from this observation from the German Constitutional Court is that they're not making a positivist argument. They're saying there's something about the spirit of the Constitution, or the objectives of the Constitution, which is not explicit, right? And so in that particular constitutional setting, a reference to human dignity is left sort of comfortably unspecified. And I think, again, clearly it could be specified by a natural law premise and so forth. So that's why I thought that sort of statement was, there you could somehow see a natural law argument possible, but filtered through the state. And again, then, from this point of view, so let's hear the argument. How does this violate human dignity? Right? If this is where you decide, so long, but no longer, this is where something. To simply say, oh, it violates human dignity isn't enough, right? We would want more careful attention. So that would be one possibility, that that pushback is not simply positive constitutional law, it's some kind of natural law underpinning of the Constitution. And the second is this sort of, we could imagine, I think, principled non-compliance by other actors than states. So what would that, it could be some NGOs, Greenpeace saying we're not going to respect international borders for this, we're not going to respect certain aspects of public international law because of some environmental concerns. Again, so that would be, again, on this view, I think, the same response. So natural law theorists would say, well, in principle, it may be legitimate to not obey, but we need to see the arguments. We're not going to do hands-off simply because it's Greenpeace, or simply because they say it's legitimate, but we want the arguments. Or do you have other actors in mind? Than
No, the thing that's from my own work, I'm always been very interested in the way international courts in particular are located within their own constitutional settings, if you like. In the Court of Justice, for example, and the way in which the court is sort of bound internally by treaties in the international law context. It's always struck me that when national constitutional courts push back against the Court of Justice, and I guess this is also true when you think about some of the reactions of, or very true when you think of the reactions of UK courts against the Court of Human Rights, for example. They always do so with reference to internal norms, or norms that have been filtered through the internal system. And that's kind of obvious, it's kind of instinctive. And I can see what you're saying about natural law can be used in the context you described to add weight and further colour and explanation to some of those arguments. But it's just sort of thinking about whether, in and of itself, natural law binds these international institutions or courts in kind of new ways, if you like, or in ways that takes us beyond the understanding of traditional positivist discourse, if you like, reaching the terms of the treaties, or with more political science, that they're not trampling all over the legislature, or they're not acting in ways that deal with output legitimacy. So kind of, because this natural law theory is very close to states, but the kind of things that I'm thinking about are more international law, more autonomous, if you like, in the sense. I mean, that's separate to the course of if you take, for example, Greenpeace, or if you take, for example, the German Constitutional Court, there would be a clash of values, because you could say, well, the international order, the international court has formed its own interpretation of particular natural law values, and then it's just basically either pluralism, you either try and manage them, or you just accept the difference. So the question of enforcement, I think, is separate, but I'm just more interested if there was a sort of autonomous sense of natural law adding anything to our understanding of how institutions, international institutions and courts legitimise their own activities. So, again, I'm looking at this through my own lens. If this does not resonate, or I've made some fatal errors, then not to worry.
No, it might this approach would say that the repertoire of legitimation strategies for courts or for treaties might want to be shifted a bit. That it's not the Court of Justice of the European Union, when it says there are many reasons not to require us to be subject to our esteemed colleagues dealing with human rights. Their arguments should not only be, well, the states have consented to this sort of thing, or we have read into the treaties human rights respect already, so that's not a problem. Or we have read into the treaties that there is only one European legal order, and that is ours, which seems to me empirically false. But that the legitimation strategies should, in addition, say, from the natural law groups. So, what are the purposes of the EU treaty? The alleged purpose is to promote trade. That is important. That is a value. But it's not that increased trade should dominate all other interests of individuals, particularly not if it harms the human rights of some affected parties. So that would be, again, broadening the scope beyond someone saying, well, states have consent, but some of the ultimate standard.
Can I just follow up with what Thomas just said, just very quickly? Because
I thought you had a different authority as chair.
No. I'm not going to talk about the Court of Justice. Jesus, God forbid, the devil. I'm talking about the European Court of Human Rights, of course. No, but like there are similar issues of principal disobedience with the European Court of Human Rights judgments. Of course, we can talk about prisoners voting problem. But here is the same issue, because like when you read the arguments of the European Court, and when you read the arguments of the United Kingdom, for example, sometimes they come from the same natural law perspective. Yeah. So, and if we take that into account, natural law doesn't help to resolve these problems, and also sometimes when we're talking about agreed values, we can only agree on some very, very high level of abstraction, and again, this doesn't help. Like, I mean, yeah, of course we can say about like many arguments that can be provided from various lenses, but it doesn't help to resolve the end, to put an end to the conflict. Am I making any sense?
Yeah.
Basically, what I wanted to say that natural law might not resolve principal disobedience of states to the, and it doesn't help to legitimize the authority of courts, especially the European Court of Human Rights, which kind of can claim more authority from natural law than the CJEU, for example. That's not a question, just a comment.
Well, yes. So there's one point here that I might have should have included, perhaps, is that there's no claim that natural law theories will somehow exhaust the issues, or that it will solve all conflicts. Right? The roles are limited to constraining or guiding the disagreements. So it's not, the fact that there may be lots of other disagreements still is not a major challenge to some of those aspirations, because it's not aimed by the proponents to be any sort of blueprint for how law or international should be. So that would be one component, and then I think another component here is that, so if the two parties want to reframe their arguments in natural law theory terms, it may well be that you reach some kind of impasse of these different concepts, these different assumptions. But I bet the arguments would not be, they wouldn't withstand criticism if they were made in that sort of way. But that's a separate. But then in addition, I'm not sure, I don't think the prisoners voting case counts as principled non-compliance, right? Because the state.
Not very principled.
No, because it.
Well, I made this argument. I have a paper published in which we argued, so myself and Phil and the others argued that actually prisoner voting debate. Well, like basically the UK saying that. If, as far as I understand, like those who committed crime, they should not participate in ruling the country. Yeah, so that's the argument, and this can be counted as a principal argument. I would say. I don't know, like again, how we precisely define principled arguments, but this is not based on like we separate it from something that is, for example, Russian government is doing in non-complying with UCA's case, where they just don't want to pay money. Like, so this is not principle.
No, yeah, that's not. But But has the UK, would that actually count as non-compliance? Because the
Of course,
UK has...
Yeah,
they don't comply.
No,
They
but
just
are-
don't change
but
the
they
law.
have they have had a parliamentary committee that's done research on this. They're
That is not enough. I mean, the Committee of Ministers of the Council of Europe is on our side, so it's not enough. The general
when you
method-
say on our side, this is
I mean, all this. Yeah. All right, it's on record.
Do you mind if I make a
Yeah.
suggestion? I thought your answer to Ben before about imperialism was really interesting. I think it'd be something that would be worth building on in your paper. So, on that basis, I think conceptually, natural law theories struggle to say why their view of what natural law is avoids this sort of imperialist lens. And I thought your answer was quite good in that these norms are found across cultures in a way that perhaps broader norms are not.
Yeah.
But I know from a trial perspective that you will run into problems of people saying, well, hang on a minute, how are you going to do that? How are you going to justify that yours is not an imposition of Western values on this perception? So it might be worth heading that off.
Yeah, and again, I might simply stop at somehow saying, so this natural law perspective illustrates that normative theories can engage in this, but the focus is on...
Sorry.
Hey, if you have questions, that's good.
We will be thrown out of here in 5 minutes.
Okay.
That's a brilliant talk.
So one, again, I find this sort of value relativism debate extremely interesting, and I would want to write on it at some point. I'm not sure whether I can fit that in here as well, but it's again, so because one part of that dialogue is so domination is then a Western concept that would support and give expression to some of the Twale criticism. So that would be then a friendly traveler, regardless, and there may be reasons internal to Western political values for not exercising domination on people who couldn't care less. So that, but that sort of constraint still seems to guide us. So that would be one thing to deal with. Another would be sovereignty. Sovereign immunity is a Western concept. It came up in the Westphalian Peace. So you third world countries are crying about sovereignty being invaded? Sorry, that's a Western concept. We take it back. Again, where the natural law theory would say. So let's hear the reasons. Why should we respect the sovereign authority of the state that basically is killing off people?
I think on that note, we have to wrap up. Thank you very much again. That was a brilliant speech. And again, as I said, in 2 weeks, we have another seminar on fake news. And this is not a fake news.
Good.